Hey guys, well, adjudicated scumbag and sovereign idiot Darrell Brooks has had counsel appointed by the state to handle his appeal. Brooks, as you recall, is infamous not only for being a cowardly murderer and total clown narcissist, he's also known for coining some of the most ludicrous objections and grounds requests ever seen in an American courtroom. He hasn't taken his sovereign idiot show on the road in his remaining felony cases, and he appears to have retired the act completely, having requested and received state-appointed counsel for his appeal, resulting from the convictions for his pointless, murderous rampage. The state has appointed Michael Covey to handle the appeal. He's a sole practitioner, and he's got substantial appeal experience, appearing in nearly 200 cases that I saw. Of note, he's also the appellate attorney on record for Chandler Halderson, who murdered, dismembered, and otherwise desecrated the corpses of his parents, so Brooks won't be too much of a shocker for this guy. So right, Brooks has an appeal of right, and in general, that's a good thing, right? We don't want mistakes in the system. So letting somebody who's been convicted ask a court to consider identified errors, that seems like a basic due process concept. Now, that's not an indicator that the errors are material or that they're actually there, or that an appeal, simply because it's launched, ought to be or will be successful. And I don't think this one will be either. But when is this all going on? Well, he was just appointed counsel in the last few days, and they have to get all the trial materials to record, evaluate that, review it, and then write up their appeal materials. That could take a long time, many months. I mean, like a year or something, potentially. Now, what is the attorney going to appeal over? Well, we don't know that. The attorney hasn't done it yet. But obviously, think about it. From the time where Brooks got involved in this all the way up until his sentencing, there are potential serious errors in the case. I don't think there were. I'm just talking about cases in general. But let's talk about this case in particular a little bit. I mean, usually you would see potentially an appeal on what are called, let's talk about things before the trial, what's called motions in limine, where certain evidence is ruled to be admissible or not admissible before the trial starts. So if the trial court allowed something in that it shouldn't have, that could be an issue. I don't think it was in this case because I think the judge was extremely careful. Again, just talking generally. Also, something that can come up is, hey, is this person competent to stand trial? And then in Brooks' case, the additional concern is, was he competent to choose to represent himself, okay, before the trial started? And there was an evaluation done on him, and he was found competent to stand trial. And of course, the judge explained to him what the risks were and the ramifications of being self-represented, and he carried on that he wanted to do it anyway. And I think it's clear from the record that he understood what was going on, even though he didn't want to use the word understand. It's not a high burden to choose to represent yourself as long as you are competent to stand trial. And again, I'll link the video in case you want to nerd out a little bit more details at the end of it. I would not be surprised to see this as an issue on appeal because everything became a train wreck after he represented himself. We all saw the clown show, so you could reason backwards from that, hey, this guy had no business making this choice. He wasn't even competent to do it. But I don't think that's the right way to look at it. The situation is, did he know what was going on around him? He can understand really what was happening, and he certainly could. It's not an intelligence test, as I talked about in the other video. It's not a competence test. It's not a bar exam. It's like, look, if you want to run all these risks, it's your life you're playing with. You make the choice. We're not going to force this lawyer on you. And he made that choice. So I don't think that goes anywhere. And I think that those are the things before the trial that could matter. Of course, in the end, I don't think it matters anyway. Even if he had kept the lawyers that he did have, they would have just been put to the task of being buried under the mountain of evidence, because rarely is a person so obviously guilty as this joker was. So the trial starts, and you have all the goings on there with evidence situations and how the attorneys and parties are handled and that sort of thing. And was there any kind of reversible error going on there? I saw a lot of kid glove treatment of this blubbering buffoon. And to some degree, the judge on one part wanted to make sure he had a fair trial, and on the other part wanted to make sure he didn't create reversible error for this situation where he was self-representing. And a lot of the ridiculousness surrounded the times when he was kicked out of the room because of the case law basically saying that if you could possibly do it, you need to have the defendant present for the trial, of course. And that makes sense. Now, at the time that case was decided, they didn't have all this electronic stuff where you could have another room where the person could continue to participate. So that's essentially what the judge did in the case. And I think she was careful to use that tool only when it was necessary, to use it for no longer than it was necessary. He was obviously creating these situations. Again, to think that this is some kind of reversible error imagines the Court of Appeals is up there looking for opportunities to let mass murderers back out on the street, that that's what they want to do. And that is not what they want to do. What they generally want to do is sustain jury verdicts unless there is reversible error shown. And in this case, the judge was extremely careful about that. So I don't see anything that happened in the trial as being the kind of error that would be reversible. And how about the district attorney, the state's conduct? And I think generally they did the same thing. They tried to accommodate this fool as much as they could. There was only once when I heard something that made me wince a little bit as an attorney, and I'm not generally any kind of criminal attorney, but still I have a working knowledge of what's supposed to go on. And that was when the DA made the comment that he could have been charged with 5,000 crimes, and that they made the decision to charge only the ones they did to be efficient with the prosecution. And that's true, I suppose. I mean, to me, it obviously is clear that he injured more people than he was charged for. But I think as far as talking about 5,000 crimes and could that prejudice the jury in their thinking against him for the crimes he was charged with, I think they should have stuck within the record and only talked about the charging of crimes for the crimes that they actually did charge. I think that was a little bit over the top. The DA generally should stay inside the record. Now, can conviction be reversed for improper argument by the state? Yeah, it can be. It comments on Fifth Amendment, dragging stuff in that's not in the record, personal attacks on defense counsel, improper vouching for witnesses. All those things can lead to a reversal. Now, the standard for reversal for improper argument and for other things that occurred during the trial, it depends on what was done and what kind of rights it affects and how material it was on the trial or not. It's extremely technical. And generally speaking, you need to show that it had some kind of impact on the case that was a material, that it wasn't harmless error. Now, on the other hand, if it's the state doing something really bad, that burden can shift over to the state to show that it didn't impact the trial. And I'm not going to go down the rabbit hole of all the appellate standards other than to say in my survey of those, I think even if this were an improper comment, I don't think it's a reversible improper comment. And I'm not saying necessarily that it was improper because I think it's true, but I remember when I heard it, I thought, man, I wish you just hadn't said that because it's such a clean trial. That's not a criticism of the DA. Man, the things she had to put up with in this trial required a great deal of patience on her part and certainly supernatural patience on the judge's part. They all could have been a lot harder than they were. So again, I think this trial was handled as obviously as fairly as it possibly could be for someone who was taking every opportunity to try to derail it with no regard for the victims at all. And that, of course, is Darrell Brooks. So Covey will spend some time surveying the record and checking out what happened in the case to the extent he doesn't know about it. He's been appointed by the state. He doesn't work for them, but he's probably got a contract where he handles some cases for them sometimes as a criminal defense attorney. And that's fine. Again, I think it's appropriate. I think his job is the kind of job that's necessary. Would I want to help Darrell Brooks in any way with his appeal? No. But I'm not a criminal defense attorney who has to think about these things, and that's on purpose. But I admire that they're capable of doing it because you have the state on one hand and all of its resources, and you have to have somebody who can check that on the other hand because mistakes are made in the system, and you want to reduce those to the degree you can. I'm not saying you want to make up stupid rules that let violent people go free, but I am saying you need to have some checks and balances in the system to make sure that it works appropriately. And we can all see that Brooks is guilty in this case and that the jury did the right thing, but there's no exception to the rule that says you get an appeal unless we're just really sure you're guilty. How about that? Because all convictions are beyond a reasonable doubt. So the rule is you can appeal. The rule is not you can have a successful appeal. So I suspect a lot of time will be spent on this to create this appeal, and then in all likelihood, this appeal will be denied. I just see it as a very, very clean trial, that the judge was careful every step of the way. And in the one case where I think maybe there was a comment made that maybe shouldn't have been made, also to my recollection, that was one of the few times that Darrell Brooks wasn't objecting. I don't know if he was waving his sign or not, but generally, if there's an improper argument or comment made during an argument, you need to object to it or else you've waived it. That isn't always true. But again, I just won't go down the rabbit hole of those standards. And if we see the appeal, then we can address the merits or lack of merit for all the things that they bring up. But it'd just be guessing at this point. But my overall impression is probably like yours, which was this was a fair trial and this verdict will stand. Thanks, bye.